Thank you.
That's it. Off we go.
Thank you. And good afternoon, everybody. And thank you again for joining us this afternoon for part 2 of UK GDPR. It's good to see so many people. I'm sure most of you were here last week and you're back today again. And so this afternoon, it's going to be a similar format as we did last week. So we're going to go through a number of topics. There'll be a comfort break somewhere in the middle. And as Alex did say, if you have any questions, either put them down in the chat box, raise your hands with the hand tool, or perhaps turn your mic on and give us a shout as we go along. But there'll be a session at the end for questions and answers. In the meantime, please feel free to interact and contribute as we go along. So this afternoon, we're going to be covering a quick recap of part 1, so as we remind ourselves what we did last week. Then we'll talk about privacy notice and some more details. We did talk about that last week, but we'll go into some details. And then subject access requests. We'll also go through what's called a data protection impact assessment. And then we'll have a comfort break there about halfway through. And we'll talk about incident response and data breach management. And then I'll give you just a brief summary of how to demonstrate compliance, or what does demonstrating compliance mean to us. And then at the end, there'll be a brief summary, conclusion, and some key takeaways for yourselves to go away with. And there's a slide on a number of useful resources, website resources that you can go and explore in your own time, and then Q&A at the end. So I'm still John. I'm still here. It's still me. Nothing has changed from last week. So I'm a certified information privacy professional and a data protection and privacy specialist. Again, just to remind ourselves, if you do want to have a talk over the microphone, just a quick introduction of your name, your organization, and your role. And if you're brave enough, anything else about yourself, that's optional. So a recap of last week, part 1. I think we talked about GDPR and looked at why we have the GDPR. And we saw that the GDPR came about because the EU, European Union, felt it was about time to revamp and update the existing law. Then it was the old Data Protection Act of 1998 in the UK, or the EU Directive of 98, and beyond that was the old Data Protection Directive. So they thought it was about time to revamp because technology had moved on so fast and technology advances. We're in the age of the information age, big data, artificial intelligence, machine learning, but the old regulations were far behind. So what we were seeing is a lot of misuse of personal data because of these technologies. So it was about time that the old laws got revamped. So that was the why. Who does it apply to? As we saw last week, it applies to really any legal person or organization that processes personal data of UK citizens. And we also saw that there are actually some penalties. We saw how huge they were. There are some penalties, and I think this is one of the key introductions into the new regulation that made a lot of organizations much more serious about implementing and complying. So the penalties were huge. We saw that there could be an up to 4% of annual turnover or annual revenue, annual funds, or about 18.2 or so million, 17 point something million pounds, which is 20 million euros. And there's also another administrative penalty, which could be up to 2% of your revenue or annual turnover, or 10 million euros. So the penalties we know were huge. There's also other administrative penalties that could be applied. For example, stopping an organization from carrying out the business until things are fixed. We looked at the definition of personal data and had some contributions from yourselves as to what personal data is. And we saw the definition within the law as, any information that's relating to an identified or identifiable natural person. So there are key elements in that definition. One, it can be any information at all, as far as it relates to someone that can be identified or identifiable. And it has to be a natural person, so they have to be living, alive. So the GDPR in itself does not apply to data of the deceased. Within the definitions, we also talked about certain aspects of data types called special category data. Some people might refer to them as sensitive data, but the special category data are a set of data that requires a higher level of protection. And we saw examples of that, which included health data, for example, political opinions, religion, ethnicity, race, sexual orientation, and data set types in that category. So these are called special category data. We talked about some key roles within the regulation. We looked at a controller, and the controller is the person or the legal entity that decides on the means and purposes of processing personal data. They make the decisions on why we keep data, why we're using data, personal data. The processor, on the other hand, are those organizations or legal persons that process personal data on behalf of the controller. So they're a service provider that gets personal data from an organization, and they do whatever they need to do with the data with instructions from the controller. We talked about data protection officer as required within the role, or one of the roles within the GDPR. This is where required. So we looked at the fact that public authorities have to appoint one. Most organizations don't. But if you do process special category data in a large scale, then you may be required to appoint a DPO. And we also looked at the ICO, which is the supervisory authority in the UK, the Information Commissioner's Office. They are responsible for monitoring the compliance with the general data protection laws and other data laws. And they're also responsible for apportioning the fines when they do get breach notifications or reports of breaches that may warrant investigation and could result in fines. We talked about the data protection principles. We saw that there were 6+1 or 7, as some people might want to say they are. And these principles form the foundation of the regulations itself. And these are the principles that we need to comply with. The principles of data minimization, integrity of data, lawfulness, transparency and fairness of processing. We looked at data portability, and so the 7 principles, and this last one was accountability. And we'll look at that later on as we talk about compliance. We talked about a lawful basis for processing, and that means if you're going to process personal data at all, you must have or have identified a lawful basis for carrying out that processing. And we looked at the types of lawful basis, starting from consent to legitimate interest. There could be contract or legal obligations as well. So we had a quick look through the different types of lawful basis. And finally, we talked a little bit more about consent, which is one of the lawful bases, the most commonly used one. And we looked at what a valid consent was, as opposed to an invalid consent, where if you had pre-tick boxes or you had implied consent. Like, for example, you might see on some websites that say by continuing to use this website, you consent to us doing X, Y, Z. Those are implied and they're not valid consent. Valid consent, you should have affirmative action. It should be freely given, unambiguous. It should be clear to the individual that they are giving a consent for you to collect or use their data. And finally, last week in part 1, we touched on.
I'm looking into that part of it now.
So was that a question? No, not a question. Okay. So we looked at the rights, data subject rights. So these are your rights, my rights, and rights of every data subject that's protected by or under the general data protection regulations. And we saw that these rights, some of them were absolute, some of them not so absolute, where they only apply in certain circumstances. Okay, so today, privacy notice. We've all heard about privacy notice in some shape or form. And this comes about because individuals have a right to be informed. One of our rights we looked at last week was we have a right to be informed about the collection and use of our personal data. So if you're collecting my personal data for any purpose at all, I want to know why. I want to know what's used for. I want to know other things about what you're doing with it, who you're sharing it with, how long you're going to be keeping it. It's a right that we have. So most of those information that you need to give an individual when you collect the information are usually presented in a privacy notice. So they usually get written in what you see as privacy notices. The most common place you will find a privacy notice is in an organization's website, because that's public, that's readily available, and it's up there. But you need to be mindful that you have to update your privacy notice if things change. If the scope of processing changes, the type of data you're collecting changes, if you're sharing it with other parties, you have to update your privacy notice to reflect the use of information or the use of personal data. So this is what a privacy notice really captures. And privacy information must be provided at the time you collect the personal data, or at the earliest soon after you do so. But in any case, I would say within a month. For example, if you don't get the personal data directly from the individual, maybe you get it from a third party, you have to give the individual the information within a month after you've collected that information. So it's key to remember that when you do some either events and you ask people to collect information or to give you their details, and they give you name, address, and other stuff you might want to collect, you have to tell them why you're collecting it. You have to tell them some information that we'll see now that are required in the privacy notice. So privacy notice itself, as a means of giving information, must be concise, transparent, so no hidden agendas, intelligible and easily accessible. And one of the places I've said that's easily accessible is via the website. It has to be written in clear and plain language, particularly if you're addressing it to a child. So if you provide services that are for children, for example, and you're collecting children's information, your privacy notice should be written in that child-friendly language. It has pictures to demonstrate what you're trying to get across, and it should be written so as they understand and know what you're doing with the information. And most importantly as well, it has to be free. You can't charge for giving somebody a privacy notice. We have seen it in a few cases where people might want to charge because they're giving you so much information, but no, it has to be given free of charge. Here's an example I just captured very quickly from Camden.gov's website. And this is a section on their privacy notice online. There's a few other pages there, but I just took a quick snapshot to show you some of the headings. It's saying there about your personal data. It's telling you about legal basis for processing your personal data. It's telling you about sharing your personal data. So it's giving you information up front. It's being transparent. It's trying to tell you what they're going to do when you interact and give your information to camden.gov.uk. So I would say have a look at your organization's privacy notice, see what information is in there and have a look at how it's presented. And most importantly, make sure that it's up to date. A lot of privacy notices are still out of date because they perhaps reference old regulations like the Data Protection Act of 1998, or they perhaps reference things that have changed in the new regulations. For example, paying for information access, paying for subject access requests. It's no longer a paid service, but in some cases you have to pay. We'll cover that later on. That's just a quick example of a snapshot. So let's talk about subject access request. If you've ever dealt with a subject access request, just type yes in the chat box. Just want to have a quick feel of how many have actually processed an access request. Now have a look in the chat box. Okay, yeah, yes, thanks, yeah, okay. So quite a number of people have, let's see, a couple of people there, yeah. Okay, so as we said in the rights of data subjects, one of the key rights, fundamental rights, is you have a right of access. You have a right to request for a copy of your personal data, of your information that an organization holds about you. So you can make a request to any organization that you think are processing your information and say, can I have a copy of my personal data? You might have a specific request. It might be a broad request. It might be just a blanket request. Say, I want all of my data. And guess what? You do not have to ask for a reason why. The organization don't have to ask for, why do you want that? Why do you need that? No. The obligation on the organization is to respond in a timely manner. But in practicality, if you think that the scope is too broad and you think, oh, that's going to be, it's going to take forever, lots of systems, you have you have the freedom to ask the individual, can you narrow the scope down, please? Can we define a year? Can we define a period? Or can we narrow it down to a particular number of individual mailboxes to search? So you have that opportunity to correspond back and say, thank you for your request. However, we notice it's quite broad. Can we narrow it down? The individual does not have to actually agree or go with you. It depends. But in most cases, it's often best practice to try and narrow down the scope, but they have that access. This is another interesting bit about subject access requests, is that it can be made in any form, verbally or in writing, and through any means into your organization. If you have a social media platform or presence, a subject access request can come through there. If you're interacting with members of the public or service users through social media, and one of them happened to mention, by the way, can I have a copy of my records from X? You need to be aware that that's being made, and that's actually a role within an organization to identify subject access requests where they have been made. And then that goes into your process, internal process of dealing with a request. But be mindful, it could be over the telephone as well. So what if it's over the telephone? What do? You make sure you write it down, you take notes, you record it in your request file, or your request register, or your request process. If you have a system, then you log it into your system, but it's come verbally and you state how it was received. It came through the phone, or it came through your system, or it came through the website, or through the social media. Those are important things to note down. And also make sure you understand that you're only entitled as an organization to give the personal data of the individual requested and nobody else's information. So any information that might be bundled up in a record or might be bundled up in a documentation, if there are other people mentioned, you have to redact those before you submit the information to the subject that's made the request. So they are only entitled to their own personal data and not information about other people. But the key thing that's often missing from what we see is that when a subject access request comes in and it says, can I have my personal data from 2 years ago to date, what organizations often do is they go and they collect the information from the system, from the email, from the server, and they have documents and say, yeah, 10 documents or whatever it is. Here you are, here's your information online, download it or whatever it is. They forget to add this supplementary information. It is important to add this additional information because that's what is required in the regulations. It says when you respond to a subject access request, you must also inform the user of the purpose of your processing. Why do you have the information in the first place? What are you using it for? The categories of data, of personal data concerned. So you say, yeah, we have your contact details, we have your employment records, or we process your health records for da, da, da. So categories of personal data that's concerned about that individual. The recipients of category or categories of recipients that you disclose your the personal data to. So if you share that with anybody else, you have to tell them as well when you're giving them the information that, yeah, here's your information. This is why we keep it. These are the types of data we keep about you, and this is who we share it with. That's important. You also have to state the retention period. This is also often missing. You have to state to the data subject. Now, these information, if you remember what we said earlier about preface notices, should have been given up front as well when you first collect it. But when you're now giving back information due to an access request, you have to put this additional information in your response. So the retention period or criteria of how you determine retention should be given to the data subject. And finally, here you have to also remind them of their rights and the rights that they have as data subject. You have a right to erase, have a right to rectify if it's not correct. If you find out that something we have given you are inaccurate, you have a right to rectification, you have a right to restriction, and you have a right to object. You remind the data subject of these rights when you respond. And finally, here you have to remind them they have a right to lodge a complaint with the ICO if they're not happy with the way you have handled their request. Information about the source of the data, if it was not obtained directly from the individual. Remember, sometimes we get data from a third party about an individual that's coming to our surveys, and therefore, if we have that information and we're giving it to them, they might say, oh, how did you get that? You have to tell them that, right, this information we got from the third party, and that should be disclosed in your response. It's not over. The existence of automated decision making, if at all you use any sort of automation as part of the processing of their information, including if you're profiling and trying to build images or trying to build pictures and data, a profile about the individual, you need to let them know that we process your information using so and so technology, which is X, Y, Z, and it has automated decision making in our whatever it is you're doing. So that's a requirement. You have to let them know that, because they have a right to object to such processing if they need to exercise that right. And then the safeguards that you have that you provide if you transfer personal data to a third country. So if that data leaves the UK, as it is at the moment, or the EEA, leaving the UK to EEA is fine for now because they're considered as adequate countries, their data protection laws. But if it goes outside the EEA, you must tell them that you're transferring it outside of the EEA to US, for example, and what safeguard do you use for that? Because those kind of transfers are called restricted transfers. If you do that, you must have something in place to allow the transfer. And that something is usually either a standard contractual clause or model clauses. And you can find these on the ICO's website, the templated forms and documents to be signed by both parties. But then there are also additional checks and supplementary measures that have come into place in the last couple of years. That's a more detailed discussion around international transfers. Okay, and as I said earlier on, you may be providing much of this already in your privacy notice. And guess what? You don't have to write everything down if you already have in your privacy notice. You can refer them back to your privacy notice, saying that for further information on how we process your information or your data, please refer to our privacy notice here. But you must make sure these information are covered in the privacy notice in question. And as I said already, you have a legal responsibility to identify that an individual has made a request to you and handle it accordingly. Now, I'll give you an example. A complaint came in, not a data subject request, to an organization I was working with. The complaint came in and it was almost 2 pages of conversation type complaints. And in there was one line that says, can I have a copy of, in that whole conversation. And this went into the complaints department of the organization and they dealt with it as a complaint. And then 4 weeks, about 3 weeks into the complaints being handled, it got seen by someone in IG, Information Governance section, who read it and then happened to understand, hold on, this line here actually is a data subject access request. We know that hadn't been the intention of the communication, in communication about complaints about service received and all that, but there is a request in there. You have to identify that as a valid subject access request, because it's, can I have a copy of a record of some sort related to the complaint? And in that process, you must make sure it goes into your SAR process, your subject access request process, because there are requirements in terms of timely response. And we'll find out a little bit. I think next slide might cover that. So it's a good practice to have a policy for recording details of the requests that you receive, particularly those made by telephone, or in person, as we mentioned earlier on. You cannot charge a fee to comply with a subject access request in most cases. Now, it used to be the case in the old Data Protection Act that you could charge about, I can't remember what it was now, £20, £10 or £30 it was, because somebody made a request for information. But in the new requirement, the new regulation, the UK GDPR, in most cases, you cannot charge for a fee for the request. But when do you charge? When do you think you have an exception to that rule? A reasonable fee is what it said for the administrative cost of complying if it is manifestly unfounded or excessive.
Manifestly unfounded, in this case, is hardly used and hardly a justification, because the way the GDPR defines and looks at manifestly unfounded is you think that the data subject is doing this maliciously. They're making a request for all the information because they have a grudge against the company, and so therefore they want to put you through hell so as you can then tie up resources and You can't really use that as an excuse not to respond. So really it's about excessiveness or complexity. That's where you might be able to have a good justification. If it is excessive or if it is complex, and I'll give you an example. So if a request comes in and you look at the type of data that's been requested in your process, you identify, you look at it, you say, okay, we know what this is, we know where to get it. But if that information now resides in 3, 4, 5 different places and actually also outside the organization, it's starting to become a little bit complex. And in healthcare, where I do a lot of work and currently work, you have to request, especially if you're with the NHS, you have to put in a request to the NHS digital services for email requests. They have a 10-day turnaround, right? So it's now becoming complex, and you're thinking that 10 days plus the days I have to then review and redact and And by the way, you only have 1 month to respond. So that could be an excessive request. 2 things could happen. It could be 1, I'm going to charge a fee, and 2, I'm going to have to increase the turnaround time, right? And then the complexity again could be, that you now getting the information from another third party who are having problem getting it from archive, who are having problem getting it. So you see, administratively, you're thinking this is going to take a lot of effort to get. We're going to get it, but it's going to take a lot of effort and it's going to take a lot of resources. You might want to consider a reasonable fee for those type of requests. Or on the other hand, if an individual requests further copies, so you've already sent a whole box of information, they usually go in boxes if you're printing them out. You've already sent a whole ton of paper for their first request, and then they say, can I have another copy? Oh, okay, you can, but it will cost you X. So in those circumstances, you are justified, or you're allowed to charge a reasonable fee. This is about the time limit. So you must comply with the requests without undue delay, at the latest within 1 month of receipt of the request. There's a little bit of a caveat there. It's when it comes in, a request comes into you, you know it's a subject access request. You then have 1 month to respond, but you can extend that time by further 2 months if the request is complex, like I've just mentioned, or if you've received a number of requests from the same individual. So that one individual sends you subject access request. Okay, I don't just want a subject access request, but I want to also exercise data erasure, but I also want to exercise subject a rectification request because I've got some information I want you to correct, but I also want access to all this information. So it's now becoming more than just one request. It's now 4, 5, 6 requests in one hit. And so in those circumstances, you can say to the individual, thank you for your request. This is what we're going to do. And by the way, it's going to be 2 months before we get back, or before we get back to you finally, or whatever it is. It's going to be 3 months. So you decide on how to extend that. You're allowed to do that. But in most cases, you have just 1 month of the receipt of a request. How do you calculate that 1 month? It's from the day you receive it. So it's calendar days rather than working days. It's calendar days. So you should calculate the time limit from the day you receive the request until the corresponding calendar date of the next month. If it's not possible because the next month has a shorter number of days, then it will be the earlier days. So you might find out that you actually have 29 days rather than 31 days in some months. So here's a little quiz. While I stop talking about calculations. You receive a SAR on the 31st of March. April has only 30 days. When is your deadline to respond to data subject? Just type that in the chat box if you don't mind, and let's see what we've got. Jenny's saying 30th of April. And says 30th. Yes. Donna's typing 30th. Yeah, 30th of April, 30th. Correct. You have until the 30th of April. Thank you very much. Thanks for that. Yes. So be mindful of the dates you receive. Now, there's a little bit of I won't say ambiguity in the way it was interpreted, but it further says that when you do receive a SAR, which we'll see later on in the process, you have to verify identity of the requester. And there's another part in the regulation that says the clock doesn't really start ticking until you verify the identity. So a request comes in today, 31st of March. You can't tell who it is. You respond back to the individual, says, can you send me identification? I need a passport copy, photograph. Depends on how you do your identification. And they send that to you and you look at it and you can't see it because the photocopy is not good enough. 2 days go by, you send it back. 1 week's gone by the time you now receive verification and you can say, yep, clear, thank you, pass. That's when the clock starts ticking, technically. So you need to be mindful. If you're doing those kind of verifications, your clock really doesn't start ticking. Your system might record as request came in on 31st, but identity verification takes 1 week. Clock starts ticking from when that's done. So just be mindful, you might have those type of scenarios. But if it's straightforward, you know who it is, it's an employee, and the employee sends you an email straight away, or the volunteer sends you an email, you know who it is, you work with them on a day-to-day, the clock starts when you receive that because you're not really doing a request for the identification. Another question, true or false? You can extend the time taken to respond by a further 3 months from the date of the request. You type that in, just TF, T or F. Okay. False, correct, false. Okay. That is correct. Thank you. Thank you, Donna, Luis, Karen. Thanks. Yep, that's false. It's just 2 months extension, so you don't count that first month, but the extension is 2 months. So here's a quick flow diagram in terms of if you don't have a process already, and this is what a process would look like for a subject access request. The first thing you have to do is identify that it is a subject access request and accept that, yes, this is a subject access request, and we now have to put it through the process. You validate and verify identity. However you do that, you use your process. Is it photo ID? Is it address? Is it date of birth? Is it what you have on your system to verify? You do that and you make sure that is clear. You deal with requests from third parties or children. So some requests come from third parties on behalf of the data subject. So you must make sure that you also have, as part of your process, how do you verify that this is a legitimate request on behalf of the data subject? You might usually have parental guidance on record. You might have power of attorney. You might have a court order, whatever it is. It might be, guardianship, but you have to have that record. You have to have that from the data subject themselves or from the third party requesting. A copy of that documentation can be provided when they make the request. So you deal with that and you satisfy that, yes, this is a legitimate request. And then in the between there, you go and you search your environment, your ecosystem for where this might be. This is the time where you think, oh, if only I had a very good data mapping process in place or a fantastic record of processing activity, I would know where this information is and I would go bang, 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 and it will come back so easily. It's never that simple. It's never, ever that easy in most cases. And what you find is people forget or they sort of overlook where data can be. And that's because they think the request is for information that's on the email or information that is in the shared drive. But they forget that people actually do share information across teams, across providers, and you have to be able to track where these information sits and resides. Hence why at the beginning in 2018, when GDPR got implemented, everybody was told to go and start with the data mapping, go and start with your data flows, go and start with your information asset register, because that would help you know what you have in-house. It would help you know where they sit. It will help you know who it's shared with, where it goes. Then when a request comes in, you put in your request to each service owner or each owner of the asset where this data sits and say, can you look into all your systems here, there, and there, because I need information for this particular individual, and send it to me. I'm talking about the coordinator now dealing with the access request, and that person collects all the information and they have the next task to do. And the next task is really the painstaking one if you've got lots of information, and that's really going through what you've collected and making sure, like we said earlier on, only information that's relevant to the individual is given. So you now have the great pleasure of going through documents and redacting. If you're doing it manually, it's painful. If you have a system, it's great, and then you can put it in a system and do some redaction, but it's never that easy because you still have to have manual intervention. You still have to read them. You still have to look at what's come out of the system to be sure that nothing is missed and nothing has been left exposed. So that's the redaction bit. And when you're then happy with what you've collected and redacted, and if you have an approval system, make sure it's approved by somebody else who either owns the data or perhaps who knows about the data. If you're dealing in healthcare or within the health information organizations, it's usually either the lead clinicians who can then do a further assessment, which is called the harm test, to see if that information should be released or not. And then once that's all approved in your system, you respond and you send the information to the data subject with those supplementary information or reference to your privacy notice. And finally, you record it in your SARS register. So it's important that you keep a register, because then you can know what's coming during the year, you can report on it, and you can do all sorts of monitoring for improvement. So that is a subject access request. So now let's have a look at data protection impact assessment. But before I do that, do you have any questions? Anybody have any questions? Anything in the chat?
John, just
Yeah.
going back to the privacy policies, there's one about do you need a different policy if you've got different services, or can everything just go in the same policy and be a bit longer?
That's a good question. If you have an audience that perhaps will come to one place for your information, then you can have one policy that have different sections. So the different sections would capture the differences in the data you're capturing. So if the data for service A is different from service B, you need to specify them under those services in your privacy policy. So you can have one privacy policy to answer the question, but be sure that you cover the services and it's clear that for this service, this is what we're doing, or this is what we're collecting. For service B, this is what we're collecting, this is what we're doing with it. And then individuals can read the one that's relevant to them.
I think that's it.
Do you need different privacy policies? Okay, that was the only question. Anybody else have any questions? Subject access requests. Okay, so we'll go on to, was that somebody?
Yeah, hi. I've got a question about privacy notice.
Yes.
The sort of accessibility, like, so it has to be easily accessible.
Yes.
So if it's on your website, but if, say, you're providing all these different services and say a client phones up and wants counselling and you've arranged an appointment and they haven't looked at your website and they're not going to.
Yeah.
So if you're, say, replying to them with an appointment for an assessment, should you attach the privacy notice to your email, or should you just mention that it's on the website, or what should you do?
Yeah, so that's a good question. Thank you. And I've seen it done both ways.
Thank you.
Seen it done both ways. So I've seen appointment letters with an attachment that says, here's our privacy policy, but then that's paper-based. And that could be because the recipient might need paper-based rather than have access to the internet. If they have access to the internet, then it could be part of the text or the verbiage in your letter itself and saying, to find out how to use your information, here's a reference or a link to our website for our policy. So you know your audience, you know who is receiving the letter or the information. You might decide letter, or you might decide website. So it's got to be tailored to the individual, really, is what I'm trying to say. But I've seen it done both ways, and you just have to understand who the recipient is. And the other thing actually is in some consulting or some clinics or some areas where you go into a clinic, it's there in hard copy. You have leaflets of your privacy notice, and you might call it, your information, your rights, or whatever, privacy notice, and they receive that as part of their registration when they come in to register in a clinic or in an environment. So where you have the opportunity to give them the information upfront.
But I mean, they haven't really given proper consent until they've seen the privacy notice. So it's you kind of have to thrust it at them if they're not bothered about it. Say, like, for instance, I mean, in counselling client, it's a typical example because they don't care. They're not bothered about privacy notice and stuff. They're there for a reason. They don't think, it doesn't enter your head to ask for it or to think about it for most people, I think. So, I mean, I imagine, if I say write an appointment letter and I just say for our privacy notice, see our website. But again, you see, the problem is like if you're providing so many different services, you could have this one big privacy notice, but you'd be constantly back and forth and tweaking and changing. So would it be better? Sorry, I've morphed into another question. I apologize. Okay. Would it be better if you've got like 1,000 different services, well, not 1,000, but lots of different services to have individual ones?
Again, it depends on how efficient how your operation is set. If each individual service is totally different from the other, you might decide to have a standalone privacy notice for each department or each service. And if each service do have their own website, fine. Or I've seen in some websites where you have the privacy notice for service A, privacy notice for service B, privacy notice for service C. That's also another way of doing it. So you can have it that way, but it will depend on how significantly different are they. If they are that different and you feel that it would be better value for the individuals, then you separate them out. Yeah. If you feel that you just want one privacy notice, the thing with one privacy notice, if you have 10 different services, you're going to have maybe 20 pages, and then the individual might then go there and say, which one relates to me? Where am I? And looking for service B or whatever it is. So you have to decide what's the best value for the individual that you're dealing with. But I get what you mean about the individuals. They just want to come and get their treatment. They just want to come and get their service from yourself. Yeah. But the obligation on us as controllers of data, as you as controllers of data, is that you have fulfilled your obligation. It is their right to have it. If they're not exercising their right or they're not really cared about it at that point, okay, that's their prerogative. But you've exercised your duty to say, right, when you came to me and I'm going to collect all this information I've given you, where you can see how we deal with them.
Okay.
Right, so that's what, if it then requires consent, I think, which we talked about last week, you have to make sure you can record the consent. So you have to collect that somewhere. I need your consent to do ABC. Yeah. Here's the form, here is the paper, here is the explicit consent, the statement of consent, and you need to record and keep that because that is auditable.
And John, just on that, can I just ask then, because quite often you'll see like it is the consent where you've got the option to tick the box, but the ticking the box is kind of accepting that you've read and accept the terms of the privacy policy. Is that's okay in a consent gathering, or?
Okay, the question would be, what is the purpose of ticking the box? Is it to say that I have read your policy? Or is it to say I consent to you using my information to do X? Two different things. So we have to be clear. If you look at the rules of the consent and what we looked at earlier on, you have to be clear. There has to be clarity in why am I consenting? What am I giving consent for? Because if you give consent to reading the privacy and privacy notice, you say, okay, you have given me this information up front, and I am telling you that I have looked at it or I have read it. That's all that ticking the box is going to be doing, is to say, yes, when I walked into your practice, you gave me the leaflet that had 10 pages of information privacy notice of how you're dealing with my stuff. It's not about me consenting for anything else. It's about me receiving that information and reading it and seeing how and what you do with my information. Does that make sense?
Yeah, thank you.
Thank you.
So just one more thing as well, what I would say is when you're designing forms and you're designing anything that's got tick boxes, make sure you clarify underneath why they're ticking the box and what you're going to be doing with that information. And a very easy one is where you ask for name, address, maybe telephone number, so that you can send people information. 9 times out of 10, they tick the box, but there's nothing underneath to say what you're going to do with that. So like good practice would be say, you know, you've consented to us sending you our newsletter on a monthly basis or whatever it is you're going to be doing with that address, name and address. And so that statement is clear. So it is clear to the person ticking the box. And it's clear to you when you look at it down the line for a review. Okay. So data protection impact assessment. Right, this is a process. If you just think of this as a risk assessment process, it's a process designed to help you systematically analyze, identify, minimize data protection risks. It says here of a project or plan, and this is how the ICO defines it. But it is really of any data processing activity that involves personal data, right? You look at doing a data protection impact assessment. You're taking a risk-based approach to assessing activities that involve the processing of personal data. We often hear it referred to as a DPIA. I think in prior legislation is a PIA, Privacy Impact Assessment. It's a similar thing, and this is the next grade up from that. When must you do one? You must do a DPIA where the processing is likely to result in a high risk to the rights and freedoms of natural persons. So if you think that you're processing information, personal data, that if breached or if there's any sort of mishandling of the information, the data subjects could be impacted, and that could cause them a high risk, or it could be a high risk impact. It could be physical harm, it could be mental harm, it could be non-material harm to the individual. That's the risk we're looking at here. So if you decide then that you need to do one, if you decide you don't need to do a DPIA, you need to document your reason. And the reason why here is if there's some, I say audits, but if there's any investigation, any sort of exploration in future, and say, oh, is there a DPIA for that activity? And I say, no, we didn't do one. The ICO, in this case, would want to see your justification for why you didn't do one at the time. So document your reason, because this is one of those requirements within the GDPR that, if not done, could meet a fine of up to 8.5 million or 2% of annual turnover, whichever is higher. Examples of when one may be required. These are just different examples. It may not immediately relate to you, but some may. So procurement of technology. If you're buying a new technology or a new application that is going to be processing, that's going to be storing, or that's going to be handling personal data, you might consider, or you might want to consider doing one. So do your screening questions. If you're procuring new systems, new devices or products which involve the processing of personal data, think risk assessment, think DPIA, do I need one? We'll go through some details in a minute of how it's done. If you're implementing or developing new processes, new technology, new systems or products which involve the use of personal data, think risk assessment, think DPIA. The collection, the retrieval, the obtaining, recording, or holding of new personal data. So this is important because GDPR came in 2018. Lots of processing has been going on prior to that. Lots of systems in place, no DPIAs. Now going forward, the minute you start to add new personal data or for a new service, you have to think of doing one, because you might be doing the same service, for example, but you're now extending it to new catchment or to new audience. If new personal data is coming in, new risks are coming in, we have to think of doing a DPIA. And most of us also, we like to use trial technology before we buy. If you're using trial technology in a live environment and it has live personal data in it, we have to think of doing a DPIA. because in some cases I've seen where I've been told, oh, it's only a pilot project. We're only piloting it for 3 months. And then after that, we'll decide if we buy. And then I ask, yeah, but what information is in your pilot system? Oh, yeah, it's the database of our users, our service users, our patients, and those are live information. Those are live database sets and live patients and live information. So I'm afraid you have to treat it as if it was a regular system, regular product that you already have implemented, and you have to do a DPIA, even for trial technology that you're just trying for a few weeks or a few months. So the DPIA process, the risk assessment, I mean, for those who have done risk assessments before, you would understand that basically you're trying to identify what the threats, the risks are. You're trying to analyze the risk to see how big, how small, how impactful, and you're thinking about, yeah, but how can I protect or reduce or get rid of the risks? So you're thinking about mitigation and controls, and then you're thinking, how can I implement those? How can I put it into practice? And then you're recording all your process as you go along, and then you're getting somebody to approve it at the end, and then it becomes part of BAU, business as usual, in the way you work. So it's a similar concept here in the process. So first thing is identify the need for the DPIA. Like we said earlier on, when do you do one? Do I need to do a DPIA? Now, it's not often very straightforward. Sometimes you might have to get 2, 3, 4 people to do this process. And what you find in some organizations is it's given to somebody, a form is given, a template is given to one person, and they say, hey, go and do a DPIA on X to one person. It will never work, because DPIA itself has to involve a number of people who handle that data, who know the data, who process it, who develop the system, who's using it, who's impacted, and that's got to be part of your process. One person, yes, can coordinate it and get the information from the different parties, but it's never a one-person role to say, I'm going to complete a DPIA and just fill in a form. It wouldn't be fit for purpose. So once you've identified you need to do DPIA, you describe the data processing information flows. What are you doing with the information? What are you doing with the data? Oh, this new system, yes, we're going to put in manual information, dates, birth, address, this and that, and then it's going to calculate X, and then we're going to store it in the system, and we're going to download a report in Excel. You describe the whole processing information for that life cycle, that data that you've got for that service. And once you've done that, consult the stakeholders. You know, this is not necessarily a 1, 2, 3 step. It could be happening and in parallel. Some of them happen in parallel. This consultation could happen throughout the cycle, but the stakeholders, the key people involved, like I mentioned, should be consulted. They know more about the system. They know more about the data. They know more about the patients, the individual stakeholders, and they know exactly what you want to do with the information. So you consult each party and you're asking them about the risk of using this information, of using this process, the risk of not getting it right, what could go wrong, and you're asking the relevant questions. This stage 4 says assess the necessity and proportionality. What the GDPR says is you have to ask yourself, is it necessary that we do that step? Do we have to do this? Do we have to put this data here? Do we have to use this step in the process? Can we just not do it because that's too risky? That's presents a high risk. So you think about options. The necessity, is it necessary? Proportionality, do we need all this data set or do we need a less data set? If we really think about the principles, data minimization, do we need to collect 10 different data types on an individual? Or do we just need 5 to satisfy the same purpose? So you limit it and you think about proportionality. Because sometimes people who design systems just design it to capture everything. Doesn't mean you have to fill in all the fields. You have to think about the ones that's necessary and proportional. And once you have those information, you identify and assess the risks. And then you think about how can we control the risk and mitigate the risks? What solutions are in place? It could be a technical risk. It could be an technical control. It could be an administrative control, like training, for example. It could be we need to write a guidelines or a standard operating procedure in order to minimize the risk that people don't use it right. So you think about the risk first, and then you identify the solutions and the controls to mitigate those risks. And then you record every step you've taken. So from the beginning, you record the DPIA outcomes. And when you get to the outcomes, it says, this is all the risks we have identified, this is what we've done, this is what we, so your template will talk you through. And there's a good template on the ICO website if you need one. I've got the ICO link at the end to the ICO. But you record the outcomes, and then you get sign off by somebody who has the authority to approve risks in the organization. Usually those who have DPOs and information governance managers might be the information governance manager signing off, and the service lead, the person who is responsible for that system or that process, signs it off in addition to an IT, information governance, or sometimes it could be chief information officer, depending on who you have as the authorized person to sign off risks at that level. And then after that sign off, you integrate the DPIA outcomes into the process, into the project. So the project goes on to completion, and then that system, if the system launch, goes live. Systems should never go into production, into live environment, unless the risk assessment has been approved or signed. That's the way it should work. But we tend to see it working either hand in hand, or DPIA starting after you've sort of a process, or completed a process, or started a process, and then people trying to backtrack and backfill it. But that's not putting in place what's called privacy by design. Think about it. The minute you start thinking of that new system, that new process, that new gathering of personal data, you start thinking risk assessment. Should I be doing a DPIA or starting one now? Okay. It's a 10-minute comfort break. So my maths, that's supposed to be my 10 minutes. So apologies for that longer break. I'm sure we appreciated it. Okay, so we're going to go on to the next half of the session now, and let's have a look. Data breach. So we're going to look at incidents and managing data breaches. So if I just ask everyone on the session, what is a personal data breach? What do you think a personal data breach is? If you wish to turn on your mic and speak, you're very welcome. If you want to jot it down in the chat box, please feel free. Just give me an idea of what you think. What is a personal data breach? What do you think it is? Or what do you know it to be? Okay, I can see somebody typing some answers there. What is sharing data with other people that should not, or that should be kept confidential? Absolutely right. That is a breach of confidentiality. Let's see on other. Okay, I've got a couple of more typing away. Leaving documents on the bus. Yes, that's definitely a breach. Hopefully, documents that contain personal data. Unauthorized disclosure of individuals' data by that individual's data by that unauthorized disclosure. Okay, yes, I agree, that's a breach. Doing this by accident. Yes, so doing any of the above by accident is a breach. Okay, that's key to note. Just a couple of more, and then I'll show you what the definition as it is defined, and you will see how it relates to everything you're saying. It's in there. So let's just take one more. Crystal is typing away. An unauthorized disclosure. Oh, that was Crystal's. Okay. So the definition I have here is this: a breach of security leading to the accidental, as somebody said there, or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data transmitted, stored, or otherwise processed. That's a long definition, but it captures all of what you've said there. But the key word I want you to maybe think about here is a breach of security. It's the breach of security that leads to all the next steps and the lines that's happening there. So you've left confidential information on the bus, you've breached security. You've left, you've disclosed unauthorized, or you've disclosed information to somebody who is not authorized to see it. Unauthorized disclosure is a breach of security. And the two things at the bottom here, that it could be either accidental or deliberate. So doing it by accident or not, as far as that breach has happened, there's been a breach of security leading to accidental or unlawful destruction. So data could be destroyed, it could be lost, it could be altered. So it changes in data, that's why validity or quality of data is important. Any changes, alteration is a breach. Unauthorized disclosure, access, so you've given access to somebody who shouldn't have it. Personal data either is transmitted, stored, it doesn't matter where the data is. All these are data breaches, and we should be mindful when they do happen. We have to then treat it accordingly, especially when we're talking about personal data, not necessarily other type of data, which also should be protected, but this is really about personal data breaches. So if you ever do suspect a breach, any of those things happen, report it as soon as possible, any time of the day, any time of the week. If you identify personal data breach, as soon as possible, because there is a timely notification that's required. So you could report it either to your team lead or manager, depends on how you set up your breach management process in your organizations. You report it to somebody who either is next up or in the executive or leadership role, or you report it through your internal reporting process. After break quiz, just type in A, B, C, or D into the chat box. Which of them is not a data breach? Okay. 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 Just gonna have one more. Okay. I can see most of the answers in the chat box are C, except for one, which is B. Will that one person want to explain why it is B, if you wish? Or perhaps type why it is B. Oh, or is there a correction? I think there might be a correction coming, but if we think about it, the answer, which of them is not a data breach, is C. Processing personal data collected with consent. That's not a breach. You've collected personal data and, you know, it's consent. It's from your website. If consent was given, so that's not a breach. All the others are examples of what we just described. The loss of personal data containing of a laptop. That's very common. We see that all the time. You receive a list of customer contact details from a retailer in error by email, in error, human error, accidental, it's a breach. Keeping a list of your members' contact details in an unlocked cabinet in your office is exposed as unsecure, security breach. Those are breaches. Okay, so one thing I also want to say about breaches is you need to be mindful that when you're reporting a breach to the ICO, you have 72 hours to report a breach that could result in a high risk to the data subject. So if there's been a breach and you look at the type of breach and you think, okay, this particular incident is serious enough to cause a high risk to the data subject concerned, or subjects, it could be plural, concerned, then you have an obligation to respond and report to the ICO. If it's going to be a high risk to the individuals as well, you also have to notify the individuals. Now, let me give you a real life example. One of the organizations I was working with, operator on the customer service or front desk received a call from, so this is a social care stroke health setting, received a call from a member of the public, a man claiming to be a father, asking for information about his child. So the processor goes through the usual stuff: name and address, name, date of birth of child. The father gives the name, gives the date of birth, and address of child. Please give the address of child. Operator says, that's not the address I have on the system. You know, have you moved? No, I haven't. Well, the address I have on the system is ABC. And father says, ABC. And the operator says, do you want me to update your information to reflect the correct address on the system? No, because my address is correct. That address you have on the system must be the mother's new address. Operator then, light bulb comes on and saying, oh, okay, looks on the system, nothing there, but then further down the system, there's a flag. It's a safeguarding issue. There's a red flag, or there's a flag of some sort that alerts which he had missed, and said, oh, there's a safeguarding issue here. Father and mother. And now the address has been disclosed to father. That is a situation where you think, this is a high risk impact. This is a high risk breach. And immediately the operator phones the upline and says, I've made a mistake here. I've given the father the address of the mother where the child is, and there's an issue where they should not know where each other is, blah, blah, blah. Looked at the records, and immediately the process kicked in and have to report it. Forget the ICO for now. The key thing was reported to the police. The police got involved, so it depends on the case. The police got involved. They were told they had to protect the interest of the data subject, the child, and of course the mother, because there's other history and case around this particular issue. And so that was the immediate action, and the process kicked in, the investigation started, the reporting started, and that particular case had to be reported to the ICO as well as the social authorities and all that. But that's how you look case by case when you get a breach. You examine, does this breach, will it cause impact to the data subjects? Is that going to be high risk? If it is, you need to report it. Plus, you might have within your different areas other reporting requirements, either by commissioners, by CCGs, by local authorities. There may be other reporting requirements that you need to be aware of, or duty of candor and other type of requirements. Okay. So, demonstrating compliance, the seventh principle. We looked at the principles last week, and we said the seventh principle says the organization shall be responsible for and be able to demonstrate compliance with the principles of the UK GDPR. This is often known as the principle of accountability. So if you go back onto the typing board and type in, how do you think, or what do you think you can show as evidence to demonstrate that you are complying with the requirements of the UK GDPR? I think while you're thinking about that, I've just seen a question Alex asked earlier on. Says, is this still a breach if no one actually accesses it? Accesses it. Let's see, will that be?
John, sorry, yeah, that was if the list happens to be in the office, but no one's actually got it outside of the office that shouldn't have. Is that still a breach, or is that just bad practice?
Is that number D? Keeping the list of your members' contact details in an unlocked cabinet in your office. Is that the question? Yeah. Yeah, that is a breach. Because if you ask yourself, is the information secure? The answer is no, it is unlocked, which means there's a risk that can be identified. Somebody could come in and have access. So in short, yes, you don't actually have to have access to it. Near misses are also breaches, and they're reportable. If you have a near miss, for example, something almost happened, you have to record that and report and treat it as an incident, right? But in this case, the security breach there's no security on the door, on the cabinet. So that's the breach. Yeah.
Thanks.
So let's see what's coming for what do you think you need to show to demonstrate? What evidence? PIAs, DPIAs. I like the fact that you're using the acronyms, the DPIAs, privacy notices, GDPR, Privacy policy, registered your organization with the ICO. Brilliant. Yeah. Yes, that's good. That's good. I think Jenny has stolen all my answers and slides, so I don't need to say much on the next slide. But that's fantastic, because you're beginning to think, what does the regulation require? What have we looked at in the last couple of sessions? You know, what have we talked about? And if we've talked about anything that says you should do this, you should do that. The seventh principle says you have to demonstrate that you are complying. And to demonstrate usually means show me. How are you doing it? What are you using to demonstrate that evidence that you are complying? And one thing I must say to you is that compliance is not a destination, not an end goal. It's not like when you get there, you stop, you've complied. Or when you fill in all the boxes and you fill in all the forms, you have complied. No, compliance is a continuous process, continuous improvement, because you're going to continue to monitor, to review, to improve, to access and improve and to update and to do all of that. So compliance is ongoing. So, but in order to demonstrate that, you've got to show you're doing something. You've got to show evidence. And I think Jenny's got it all in one there in that particular chat box. But let's look at some of the evidence here that I've written down that's similar. So you have to be able to have established a lawful basis and transparency for all data processing, personal data processing. If you remember when we talked about this and we looked at the principles, we say you should not be processing personal data if you don't have a lawful basis for doing so. So you must establish a lawful basis. The transparency side. Okay, an example of lawful basis to remind ourselves is consent. We had legitimate interest, legal obligation, public interest, and the others. So, but in this case, establish a lawful basis and be transparent. Privacy notice. If you have a privacy notice, it means you're showing that you've thought about what you want to tell the data subject. You've thought about the things that need to go into the privacy notice, and you have one because there it is. That's my evidence. I've got an up-to-date, has to be fit for purpose, up-to-date privacy notice. Technical and organizational measures. The cabinet in that office. That cabinet in that office has no lock. There's no door, there's no cabinet lock, there's no key. You need to put one there. How do you protect information, controls around protection? So physical controls for physical protection of the office, IT controls, these are technical measures. You're looking at organizational measures, policies and procedures. What do you have in place? What organizational governance policies, procedures have you got? Data protection policy, everyone should have one. Do you have one? Is that in place? So I'm beginning to see, when I see that, I'm beginning to see elements of compliance, elements of compliance. Not that you're compliant or you've complied fully, but these are elements of compliance coming into play because you're putting this framework around your organization. Information security policies, they've always been around. IT has them, and in there it shows how to protect all types of information, all type of personal data. Subject access request policy, you should have a policy for that. Not only because it's, with subject access is a right of the individual, and guess what? Data subjects are becoming more aware of their data rights. And in most organizations, we're beginning to see an increase in subject access requests. And that's because the general awareness and the education and people are becoming aware of it. You as individuals for your organizations also now aware of it. You'll probably be going out at some point and say, I have this right to. Hello? I think there was a drop off there. Can you hear me? Can you hear me?
You're blinking in and out. We lost you for about a minute.
Okay.
But you seem to be back now. I think you're back.
Thank you. Good on this end. Thank you. Okay, so technical and organizational measures. So look around your organization, see how data is protected, see what information or what guidelines, what policies are in place, right? Do you have data protection impact assessment as part of your processes? Is it part of your thought process, your workflow when you're introducing new systems, new processes? If I see DPIA's register and I see an activity and there's a risk assessment done, I understand, I begin to think, yes, they're on the road to compliance. Record of processing activities. Now, this is one we haven't really talked a lot about, but there is a general requirement. Article 30 says wherever you're processing information that could present a high risk to individuals, such as special category data, you must record or keep a record of your processing activities.
John, sorry to butt in. I think people have lost the PowerPoint, I think, in the connection. Could you maybe stop sharing and reshare it?
Okay.
You can see it now? I can see that. Is that better? Yeah.
Are we back? Everybody seeing it? Yeah, I say yes. Back now, yes, thank you. Okay. Okay, so record, thank you all. So record of processing activities. So basically it's a record that contains information about the processing activity you do. So if you're providing a service and it's counseling, for example, counseling was mentioned earlier on, and it might be let's just say generic counseling. What does that process involve? It involves the patient coming in, the registration, collection of information. It might be then that's used to do an assessment, and the report is written, and then that process needs to be documented in a flow map first and foremost, but then you need to then put some information down under that counseling. What is the purpose of the personal data I collect from patient A or categories of patient? It's used for providing counseling services or something of that effect. Then you have to collect the other information that's required. For example, what's the legal basis? Yeah, providing health and social care maybe. So you use Article 9 through H, or if it's contract, if it's consent, whatever the lawful basis, you document it in your record of processing activity. You also document who is it shared with. Do you share it with other care provider or the counselors or other bodies, or do you share it with another third party? It's recorded in this particular document. Where is it stored? The information. Where is it stored? It's documented there. This record of processing activity, or ROPA, is what really helps you when you're looking for information, for example, to fulfill a subject access request. You refer to the record, it tells you in, most people use Excel, there are systems out there, or it tells you, and the ICO website has the templates for record of processing activity for a controller and for a processor. But this is very good demonstration that you're complying. Not all organizations need to document this. There's a caveat there. It usually says if for organizations who have 250 plus employees, needs to fill in a record of processing activities, or if you're an organization that regularly process special category data as part of your service that you provide, or perhaps you're monitoring a large area like CCTV monitoring, for example, of data subjects, then you need to fill in a record of processing activity. Okay, so just trying to get this to move. Training and awareness. Do you provide training and awareness? Fantastic, because you're all on this session today, so you're getting some training and awareness on GDPR, but do you provide training and awareness for all your employees? All employees, not just those who have responsibility for managing the SAR or managing the privacy notice. All employees should be trained on their data protection responsibilities. So a general foundation level training will suffice. Do you have processes to uphold privacy rights? I think we talked about this already. So this shows when you're demonstrating compliance because you have a SAR process. You have a breach management policy or process, an incident management policy, right? This is going back to technical and organizational measures, but this is about the rights. Do you have processes that will save a user, or maybe service user, data subject calls up and says, I would like you to stop processing my data, stop sending me newsletters. Do you have a process to deal with that, to respond to the done on this date it's stopped, or if it's a deletion request, right, to be forgotten, and the SEN says, can you delete all my information you have? If it is possible in certain circumstances, you can't delete information, but you consider that and say, yeah, I've got a process, I assess, we do, then we delete. If we don't delete, we tell the individual, why not? Do you keep a data breach register? If I ask for a data breach register in an organization and they have one, good, I can see that, yes, they are understanding what they're doing, they're keeping register, they're keeping records, and that's the requirement there. So I can see the breaches that you're recording. I can tell that, okay, compliance is in progress. Have you appointed a DPO where required? We talked about DPO last week. If you don't require DPO by law, you should still designate someone who's responsible for data protection. You should still have somebody who is the guardian or the champion or the overall accountable person for information security and data protection, especially. There should be somebody who's got that as part of their role. It shows that, yes, the organization are really serious about looking after information and they have somebody who's responsible for that. So just as a conclusion, not that it's going to summarize everything, but it's just a conclusion, the GDPR is the legal framework that sets guidelines and rules for the collection and processing of personal data of individuals within the UK. It sets guidelines and rules. You can't know the whole guidelines. There are 99 articles in the GDPR itself, right? You can't know everything that's required, but the basic principles, the key things that are required, we've covered most of them in the last couple of sessions. And your compliance, demonstrating your compliance, will start by you asking those questions. Do we have this in place? Is that up to date? Are we, meeting the requirements here? Can we respond to a subject access request if we get one? Do we know what one looks like? So you begin to ask these questions and put things in place. Doesn't have to be overly complex. There are different, this legislation was built for all organizations, from the one person limited organization person to a multinational organization, same principles, same regulations. So you just have to tailor it according to the size and the complexity of your organization, okay, and put the requirements, the key requirements in place. We all have a duty to protect the personal data that we collect and use. Every single person in the organization has a duty to be responsible for personal data. Why? Because within your role, whatever your role might be, you will come across personal data, either by accident or unintentionally. Personal data will come your way. It might be that you receive that email in error that's got a list of all these contacts that you have nothing to do with you. That's a data breach. When you recognize that, immediately you see that, you think, oh, I know what to do. This is a breach. I'm going to send it back to the person or tell them I've deleted it. Depends on how your breach method is or your process, and then report it and document it. That's understanding your responsibility within your own organization. I mean, we talk about human error, and I think the Charity Digital, I think, did a report, I think it was earlier this year, and the ICO actually received maybe about 2,500 data breach notifications for the quarter between January 2020 and 2021. And out of 2,500, there was about 172 breach reported from charities. And out of that 172, 58 were cyber attacks or cyber crimes, classified cyber crimes. Guess what? The majority, 114, were human error. Human error. And that's mostly saying, I've sent the email to the wrong person with the attachment that they should not have seen, right? Stuff like that. Or I've posted confidential information to an address. It's gone to the wrong person because the address was out of date. And these form a lot of the breaches we see, not just in charities, but most organizations, just human error. So bear in mind everyone's responsibility to be mindful of how we treat and handle personal data. Some key takeaways now. Always think security when you handle personal data, just what I have said. Always think, I've got personal data, I've got to think protection, how am I going to handle this? Who's it shared with? Where is it kept? Is it secure? Know where and who to go for assistance. So if you're not on your own, working by yourself and all, by yourself in the organization, if you've got other people there, know where to go for assistance. If it's not internal, it's external. We've got lots of organizations that you can go to for assistance. The ICO are also open to receiving calls from anybody who wants to ask about data protection. Do not collect personal data that you do not need. This is a big one. People collect information they do not need to collect what they're collecting. Recognize when there is a data subject access request. Always ask if a customer service user is asking, can you send me? Is that a subject access request? Go into that motion because you're on a timer and you have got to respond in accordance with the requirements. And delete personal data when no longer needed. We talked about retention a bit and we said, only keep personal data for as long as you need to, not keeping it for just in case you need it later. And report data breaches ASAP as soon as possible. Do not share personal data without checking that you're allowed to do so. Here are some useful resources, like I mentioned. You've got the ICO Commissioner's Office, lots of information there. And the specific sites I've mentioned here, like fundraising and data protection, again, the ICO. Direct marketing guidelines by the ICO. Charity Digital, which I mentioned earlier on, some good stuff there on systems, platforms, and security. And of course, voluntary action campaign for training awareness and other services that they provide. Thank you very much. Let's come to the end of the slides, end of the session. And I'd like to invite any questions at this time. I see a question there. Let me read the first one. It said, is ROPA kind of the same thing as the Information Asset Register? That's a really good question because I get this all the time and it's confusing for some people because they think we've got an asset register, therefore it's a ROPA. The short answer is no, it is not. An Information Asset Register can help you complete your ROPA. It shouldn't be the other way around. The record of processing activities has some mandatory fields that you need to fill in the record of processing activity. The Information Asset Register could maybe just have the information asset, information owner, where it is, how old it is, if it's got a contract, and specifically about assets, asset management. But the record of processing activity has the information that's required to understand how is the information processed, where is it sent, who has it, where is it stored. The information can be stored in an asset that's recorded on the information asset, if that makes sense. So they're not they're not the same thing, they're separate. Any other questions?
John, I just wondered, just thinking about my own experience of this, I guess when in 2018, when everybody was panicking about GDPR, we all kind of, did a whole load of stuff and put these registers together. We built policies and so on and so on. But then it kind of feels a little bit like it's not become so much of an everyday part of the routine of what we should be doing. So what tips can you give around how we kind of embed this and make this something that we're thinking about all the time and not just like a tick box exercise that we did once upon a time?
Okay, good question there. Yeah, thanks. I think we have to break it down into processing activities, always about the processing activities. So if, for example, that's the first thing, processing activity, but then there has to be an oversight. Somebody needs to be doing a check somewhere. So I know organizations of different sizes, you might not have internal quality people or internal information governance, but somebody will check at some period in your timeline to say, have we updated our policies, for example? Have we updated our records, as an example? The policies that you built at the beginning, like, for example, the privacy notice or privacy policies, they're expected to be updated at least annually. So that goes onto a schedule of policy reviews and annual reviews. And when you write the policies and you publish documents, you have a review date on them. So you try and make it part of that workflow. It's always bring it into your document control or your document workflow, what you have already. And so documents that are written becomes part of that. They get reviewed at the period and somebody checks that the documents have been reviewed. So you might have a checklist, about information security policy, data protection policy, whatever policy you have in place. Have they come up for review? Have they been updated? Great, it's done. In organizations that have dedicated information governance, data protection officers, or other specific data protection resources, they will be checking that as well. And they will be checking to make sure that they're chasing the document owners or the information owners to update documents. Living document, ROPA is a living document. But what we saw is in 2018, everybody started doing huge spreadsheets of thousands of lines of documenting information and what we do, what we process as a one-off activity, which was wrong. It wasn't supposed to be a one-off activity. It was supposed to be a living document that you write, you capture the information, that timeline is there. If nothing changes, that document doesn't change, or that ROPA doesn't change. Nothing changes in your process, it doesn't change. But guess what? Things do change, because you might then add a new service, you might then add a new information source, or you might add a new sharing partner. At that point, when those things change, somebody with responsibility should prompt. We need to update the record of process and activity. But also that record of process and activity should have a yearly review at least. That's my tip. At least once a year, somebody's reviewing and asking, not necessarily going through all the 101 or thousands you might have, but asking information owners, have you reviewed your information, your record of process and activities? Yes, we have. Data reviewed and it's documented. So it's got to be that continuous improvement cycle that I can say we have to have that process in place somewhere in the organization. Somebody's checking, somebody is making sure that records are updated, whoever role it is to be the oversight or the person who has oversight about compliance, because you have to comply with health and safety, you have to comply with other requirements. You also have to comply with data requirements, data regulations, and information security regulations as well. Okay.
Thanks, John.
I can see up. Yeah, Karen.
Hi. I just wanted to check. I assume the rules are the same where you're holding data about somebody in their professional capacity. So, for example, we work with schools, and because obviously they're not natural people, there's always one or two individuals who are contacts within those schools. So presumably then, if the person that is our kind of point of contact for the school were to withdraw their consent to hold their email address, for example, we can still keep the information relating to the school, but we'd need to then obviously find somebody else within the school to consent to be the point of contact. Is that how it would work? Yeah,
the consent in this case you're asking is about point of contact rather than consent to use information, I'm guessing, because the information you're using is information of the school, the children perhaps, or the students. Is that correct?
Yes, but we don't have data that would identify individual students. We'd probably have data about number of students, ethnicity, free school meals, and so forth. But it's that kind of, I suppose it's that kind of individual's email address that we use to be able to stay in touch with that school, send them newsletters, send them our information about our program and so forth.
Okay, yeah, in this case, you will have to have just a replacement of the contact, because it's business to business or company to company, and you're just missing, or you're just replacing a contact. It's just like same if you have a contact in a sales organization and that person leaves, they get another person, they start chasing you, saying, here's my details, because the person you're dealing with has left. And so you need to get a new contact, and that new contact replaces the old one, and the old contact, if you have a request to remove the information, you will remove the information, or even you perhaps have a process that removes the information anyway after they leave. Because data retention, if you no longer need that contact's details, why are we keeping it? Yeah. We then need to link up with the school authorities or whoever is it, who's going to be our bridge or the new contact for the purpose we already have in place. Yeah, and so that new contact goes on record. But yeah, if the old contact says to you, I no longer work for the school, or I've left school, please stop or remove my information, then you need to remove their information rather than what's behind the transaction, what you already exchanging.
But presumably, if we're holding their email address, if they haven't left the school, they just don't want to be our point of contact anymore. But it's a school email address. Presumably, they can still request that we delete that information, even though it's in their professional capacity.
Absolutely, yes, because it's their email address. Although it's for the organization, but it's still theirs. It's still personal data.
Yeah.
With context, it works because they're saying, that's my personal data for work. I don't want it to be on record or with you for the purpose of sending the information to them. So you just take them off as the contact. Yes.
Thank you.
Yeah. Okay, any other questions?
Can't say any more, John.
Okay, so thank you, everybody.
So yes, thank you, John. What a session. It's just so incredibly complicated, isn't it? I think the GDPR, and there's so many different aspects to it, so many nuances of how to interpret all of the different bits and pieces. But I think we've definitely got a grasp of the basics. And yeah, thank you ever so much for your time. If people have got other questions or things that pop up, I'm sure you can field them to me and John. You'd be around for a bit, were you, to answer anything over email, maybe. Also, yeah, just to sort of reiterate that we will upload the notes and the recordings and everything else. I think actually got some old templates from when we ran the GDPR session when it first came out. So I'm going to probably ask John if he'd just have a look over those templates for me, just make sure that they're still okay. And then if they are, then we can share those out or kind of link to anything on the ICO that would be, save you having to think about it yourself, basically. So yes, I'm going to send out the evaluation forms in a minute. So thank you all for coming. And yeah, big thank you to John. Enjoy the rest of your evening, everyone.
Yes, thank you, everybody.
Bye.
Bye.